Claim for damages can be used to compensate pecuniary losses caused by an exchange of information or a breach of fiscal secret in a broader sense. We all know, or have learned yesterday, that tax transparency is increasing rapidly. This states thus especially enlarge the exchange of information. This enlargement has two dimensions. Firstly, the quantity of exchange of information in international tax law increases. Many new rules based on the proposals of the OECD are implemented in domestic law or all over the world recently. Oh, they don't hear me. Oh.
Could you close the
closer?
Yeah.
It's better? Yeah. So, is it okay? Thank you. So, firstly, the quality of exchange of information in international tax law increases. Many new rules based on the proposals of the OECD were implemented in domestic laws all over the world very recently. States enter into new conventions like the MCAA regarding country-by-country reporting. Information is exchanged automatically, and some people even doubt that tax authorities can use all the information in an appropriate way due to a lack of personal resources or technical resources. Secondly, and that's with respect to legal protection is more important, the quality of information becomes higher. States used to exchange preliminary numbers regarding earnings and incomes. However, today are rules in place which allow an automatic exchange of advanced tax rulings and advanced pricing agreements. They will usually contain more or less detailed information about the taxpayer and its business. Therefore, there can be many reasons to prevent or restrict exchange of information using legal action. So my short presentation will be divided mainly in three parts. Most remarks are based on the example of Germany. Therefore, I will summarize the legal basis for exchange of information from a German point of view in my short introduction. Afterwards, I will make some remarks on legal participant consultation and notification rights, which are the basis for effective legal protection against exchange of information. However, I know that in some countries there are no rules on legal participant consultation in place. I will make some remarks on this point. Then we come to the legal protection itself. It is well covered in the numbers 3, 4, and 5. Temporary legal protection, main proceeding, and damages. And I will end my presentation with some substantive pleas which can be used in court to apply for temporary legal protection successfully. So, no? I think so, yeah. So, OECD places emphasis on tax transparency to counter harmful tax practices. The most important tool is the exchange of information. And as I told you, it is increasing rapidly. BEPS project covered these points in the actions 5 and 13. In action point 5, the OECD proposes an exchange of advanced tax rulings and an advanced pricing agreements. In BEPS action point 13, the OECD proposed the country-by-country reporting. These rules are implemented into European law very recently. I think the final results of the BEPS outcome were published in the end of 2015, and now, a rough year later, they are European law and they are German law. The Mutual Assistance Directive was amended 2 times. I think Victoria Werner told us yesterday extensively on that. And Germany also has implemented the rules in the so-called BEPS implementation bill in late 2016. Automatic exchange of advanced tax rulings, advanced pricing agreements, and country-by-country reports in the European Union will now take place automatically, and the country-by-country reports will also be exchanged automatically under the signatory states of the MCAA. I believe that is not the end of the development. In my opinion, the exchange of information will be even enlarged beyond the mentioned measures. The OECD proposes a global exchange of advanced tax rulings and advanced pricing agreements, for example. So the importance of legal protection against these measures will increase as well. Some remarks on the legal basis for an exchange of information. We have double taxation agreements in place. Most modern conventions do contain a clause which is similar to Article 26 OECD Model Convention, the so-called broad provision. Germany tries regularly to negotiate such clauses in the new DTA. The DTA allows an exchange of information regarding the application of the DTA itself or for purposes of domestic taxation. However, especially older DTA do contain a clause which only allows exchange of information for application of the convention, the so-called narrow provision. Then we have several tax information exchange agreements in place and a relatively new development, the MCAA. The MCAA is insofar a new form as it is at more than 2 states enter into the MCAA to exchange information. And here one speciality occurs. Even states which are not connected by a DTA can share information on the basis in great scale, not only on a case-by-case basis. For example, Brasilia and Germany both are signatory states of the MCAA regarding country-by-country reporting, but there is no DTA or mandatory mechanism for dissolving disputes in place. In my opinion, this gives rise to new risks of double taxation without any mechanism to mitigate them. This also increases the need for legal protection and damages regarding international exchange of information. The legal background of exchange of information in Germany, well, first we have European sources of law, the primary law and secondary law. I think we learned about it extensively yesterday. And under German law, important is the constitutional law, as Professor Hay mentioned yesterday, and on the basis of sub-constitutional or ordinary law, we have some provisions in place which are very important. Firstly, it's Section 30, the fiscal secret. And secondly, there is Section 117, subsection 2 in conjunction with DTAs, TEAs, or other legal bases for exchange of information as the Mutual Assistance Directive. And Section 117, subsection 2 allows basically to exchange information if the requirements of the DTA or the other international law bases are met. And then we have, in German law, Section 117, subsection 3, the goodwill disclosure, and here this allows an exchange of information even if there is no obligation under international law, if several requirements are met. Reasons for legal protection, I would like to add are firstly the protection of fiscal secrecy. Even if there is no danger of pecuniary losses, this is a reason itself granted under the German constitution, as the taxpayer can decide in principle on its own if he wants his data disclosed or not. This applies for legal persons as well. Then, reasons for legal or for undertaking legal steps can arise from the protection or the need for protection of business secrecy. Business secrets are protected in a special way in the law of exchange of information and are usually unlawful. Obviously, the disclosure of business secrets can cause massive damages. However, there may occur disputes between the tax authorities and the taxpayer if the information in question is a protected business secret or not. Another reason can be negative consequences for business partners abroad. If the exchange of information is used for imposing taxes on business partners abroad, this may have bad consequences for the relationship between the taxpayer and its business partners abroad. Therefore, from the point of a German or a domestic taxpayer, this also can be a reason to undertake legal action against exchange of information. And then we have double taxation risk and even reputation risks. When it comes to participant or legal participant consultation and notification rights are the basis for effective legal action against exchange of information. Otherwise, the taxpayers might be not aware of the planned exchange of information. And this applies in both cases, if the state requests an information or is intending to answer information. Then we have the notification rights and we have legal participant consultation, or in Germany the chance for legal participant consultation. The taxpayer can use this instrument to convince the tax authorities to distract the tax authorities from the exchange of information. Anyhow, we come to this later, the German tax authorities are forced by administrative guidance to take the taxpayers' concerns seriously. In some states, tax authorities are not obliged to give notice to the taxpayer or to exercise legal participant consultation before undertaking exchange of information. Examples are, due to my research, Belgium, Spain, UK, the Netherlands, I learned yesterday, and Finland. In my opinion, this is a real lack of legal protection, as the taxpayers are not aware of the intended exchange. Effective legal protection is not possible in such environment. But we also learned yesterday that the General Attorney to the ECJ is on the opinion that the Charter of Fundamental Rights requires such notification rights. He seems to give some hints of this in this applied in the Berlioz case. Detailed rules of legal participant consultations are set out in section 117, subsection 4, German General Tax Act. Therefore, in the legal standard case, the tax authorities should exercise legal participation in every case. However, in most cases, this must take place because, according to this provision, a legal participant consultation must take place if the taxes in questions are administered by the federal states of Germany. And the federal states, the Bundesländer like North Rhine-Westphalia or Rheinland-Pfalz or Bavaria, do administrate most of the important taxes, especially income tax and corporate income tax. But there are some exemptions of this principle. Tax authorities can decide in their discretion if the exchange is carried out on the basis on the implementation bill of the Mutual Assistance Directive, or in cases of section 91, subsection 2 and 3, last provisions will apply especially if the immediate decision appears to be necessary because of immediate danger or in public interest. The Federal Ministry of Finance has given detailed guidance to the tax authorities in a circular on information exchange, which was updated, I think, last year, or no, it was in late 2015. According to this, taxpayers shall always be given due notice before the exchange is carried out. This is necessary to be in line with the fundamental rights to effective legal protection granted under the German Constitution. Even if an exemption of mandatory participant consultation applies, the tax authorities have to decide on a case-to-case basis, considering the rightful interest of the taxpayer, whether the consultation is necessary or not. However, it is set out in the circular that particular consultation is dispensable if the base information or if the information it is based on is filed by the taxpayer. This would be, example, the case in all information contained in tax returns or in the new country-by-country reports. In my opinion, or I would advise taxpayers to raise objections directly with the filing of the tax return to make sure that the legal protection takes place. So to sum this up, legal participant protection on the basis is a basis for the requirement of legal protection. The situation in Germany is quite satisfying, but in other countries without such systems, I think legal or effective legal protection isn't granted sufficiently. Well, now our situation, we have tried to convince the tax authorities in the legal participant consultation. Perhaps they decline our ideas, and now it comes to court. And the first step will usually be to apply for temporary legal protection. Problem under German procedural law is that legal action in the main proceedings do not usually have suspensory effect. Therefore, the taxpayer must undertake more steps here, in particular, file or apply for a preliminary injunction. It is a so-called einstweilige Verfügung. The taxpayer has to file for it at the competent court. This is in Germany pretty easy to determine because it's always, or in 99% of the cases, the Fiscal Court of Cologne. The reason for this is that the competent authority who carries out exchange of information is the Federal Central Tax Office, which is based in Bonn, and Bonn is situated in the district of the Fiscal Court Cologne, and it's always the second department of the Fiscal Court Cologne which deals with such matters. A preliminary injunction will be handed down by the court if two requirements are met. Firstly, the taxpayer must convince the court that he has a claim for preliminary injunction. In this case, this is the case if the requirements of the legal basis for exchange of information are not fulfilled. Usually in the main proceedings, facts have to be full evidenced, but the temporary legal protection, and here the procedure for get a preliminary injunction should be fast, and therefore it's only necessary to furnish prima facie evidence. In other words, make the court believe that the taxpayer's presentation or his argumentation is likely. Secondly, there has to be a reason for the preliminary injunction. This describes the need for the temporary prohibition of the exchange. And this is always given as an unlawful breach of tax secrecy cannot be undone. I think Professor Hai mentioned the system yesterday. But it should be noted that applications for preliminary injunctions are in almost all cases unsuccessfully. To my knowledge, in the last perhaps 10 or 15 years, only 2 applications were successful, and these both cases were mentioned yesterday as well. It is the case in 2005 with the exchange of information with Turkey, and the other one, 2015, with this informal exchange or discussions of business models of the new economy. But this should not mean that the preliminary injunction is an ineffective tool. As I mentioned at the beginning, the quality of exchange information increases, and therefore, if you prepare the injunctions carefully and analyze the situation and the relevant legal provisions, the court might hand down the preliminary injunction. So, assuming you get the preliminary injunction, now it comes to the main proceedings, and in the main proceedings, the court will decide the case finally, and if you're successful, will prohibit the exchange of information. Important to notice, if you don't undertake the steps and file for the main proceeding, the preliminary injunctions can be challenged by the tax authorities. And regarding to the main proceedings, we have to distinguish two situations. Firstly, situations in which the exchange has not yet been carried out. The procedural instrument here is an injunction suit, and the taxpayer can make the court to prohibit the exchange permanently if it is evidence that the requirements of the information exchange are not fulfilled. Very important to notice, the court has to investigate the facts ex officio. If relevant facts remain unsolved, the tax authorities burn, in the main case, the burden of proof, and therefore it is in so far a little bit easier than in the proceedings to get the preliminary legal injunction. Secondly, situations may occur after the exchange has been carried out, and here the procedural instrument in question is the so-called declaratory action. And it may be useful to prevent exchange in similar situations in the future, or even for prepare an action for damages against the state. This brings us to the next point, damages. And well, the function is quite clear. With damages, or with a claim for damages against the state of Germany, the taxpayer can be compensated for pecuniary losses which are caused by an unlawful exchange of information. However, the requirements are really hard to meet. We first need an infringement of an official duty. Well, it's so far easy because this is the exchange of information which was carried out unlawfully itself. Secondly, this must have happened willfully or negligently. But, and then the infringement itself has to cause financial or pecuniary losses. And now very important to notice, if the taxpayer has not tried to mitigate or prevent the loss by using reasonable legal actions, he loses his claim. Problem is insofar that that in fact forces him to file for a preliminary injunction, and if the court refuses to hand it down, then the tax authorities can obviously easily say that the unlawful breach wasn't willfully or negligently. So insofar it might be a problem. And another problem is that we come to this later. Additionally, I thought about basing a claim for damages on the EU law, here the Frankovich doctrine, and should apply as the unlawful exchange of information is an infringement of EU primary law. And but here the requirements should be also hard to meet because it requires a qualified breach of EU law, and this is usually the case if, or in connection with data protection, if the breach in present is made willfully or negligently. But this might help if there are no notification rights in place, because then the taxpayer wasn't able to undertake the necessary steps. So to sum it up, regarding damages, there is a potential lack of effective legal protection. And the states which answers our request is especially not liable for, or usually not liable for, unlawful actions of the requesting state, e.g. breach of tax secrecy. However, this would be, in my opinion, right regarding the polluters pay principle. And additionally, a remark: in many DTA or in the adding materials, there are set out that the requesting state is liable for any unlawful use of information under its domestic laws, but it is sometimes, or it might, especially outside the European Union, might also, it is guaranteed in the DTA, might be hard to force the states for its own courts to pay damages. So the last 5 minutes I will spend on with some remarks on substantive pleas. Up to now I've presented the procedural tools for legal protection, but obviously they can be only successful if they are based on good reasons. Therefore, I will end my presentation with some remarks on the typical substantive pleas which can be successful in court nowadays. These are only a few examples. So the basic idea is very clear. You have to argue and to prove that the requirements of the provisions which allow the exchange of information, especially section 117, subsection 2, are not fulfilled. This provision is applicable in conjunction with the international law basis of exchange of information, especially double taxation agreements. And these double taxation agreements do contain the principle of subsidiarity. According to the OECD Model Convention, states may only request information which is foreseeably relevant for carrying out the provisions of the convention or taxation according to the domestic tax laws. This applies to all forms of exchange of information, even spontaneous and automatic exchange under DTA. And according to the jurisprudence of the Federal Fiscal Court of Germany, an information is only foreseeably relevant under two conditions. Firstly, there must be the possibility of a taxation right as a consequence of the facts in question in the requesting state. And secondly, the requesting state, and this is actually this is more important in case of spontaneous exchange of information, there's no awareness of the other state without the exchange of the relevant information. But the taxpayer can claim that the other state is aware or could be aware of its taxation right, and this is especially the case if the information in question is contained in a tax return or in a balance sheet. Then the second question is the relevance of the it's the relevance of the requested information. I talked about the relevance of the information 1 minute ago, and will now come to the principle of subsidiarity. And this requires that the state has to exploit all the legal sources for relevant information available under the international taxation procedure in the first place. So the taxpayer can claim that the requesting state has not exploited all regular sources. In particular, for example, a German General Tax Court says that one instrument, pretty simple, to investigate is asking the participant. So if the taxpayer can present a document to the tax authorities that he filed the information or that he hasn't been asked by the foreign tax authorities, this would infringe the principle of subsidiarity, and according to the OECD commentary, the exchange of information would be unlawful. Well, this was the case we talked about yesterday, so due to time I'd like to skip it. And last remark, if the protection of fiscal secrecy is in danger, well, here's important. Well, we have to, in the DTA, there are two standards. First, the domestic protection standard. So every state has to treat the information as secret, as in the same manner as information obtained under the domestic laws. And second, more important, the international fiscal secret. And now the taxpayer can doubt if the fiscal secrecy is secured in the requesting state. But here is important, we see this from many decisions of the fiscal court in Cologne, not only to come with the quite broad remark to the court, but present evidence, prima facie evidence. In the case yesterday, Fiscal Court Cologne, the Turkish case, there was the taxpayer presented a detailed expert opinion which took in regard interviews with Turkish accounting firms and media, and so it was very detailed, and therefore the taxpayer gets the requested preliminary injunction. And the last point, under the DTA and even the Mutual Assistance Directive, exchange of business secrets is prohibited. The problem is to define the term business secret because, and according to the German Federal Fiscal Court, it is a protected business secret is of